Welcome to week 4 of ARTM 455, and we're going to be speaking in this video, and Ralph Creviso will be doing much of the speaking because that's his whole professional background, is working with labor and labor relations and human relations. But we want to talk about managing particularly conflict in a union setting. Now, for orchestras, that's a pretty common thing. Most musicians in most orchestras, even the small ones, are represented by a union. In the theater world, it might be stagehands, it might be box office employees. In the ballet and opera world, it could be different unions for different groups of performers as well as stagehands. Almost certainly, in some way, your life will be affected by unions. And that's why this is important to understand. Ralph?
In the Blackboard background material, we've given you kind of a primer on labor relations. And it gives you a context for what unions are involved in performing arts and takes you through essentially the structure of what are the employer responsibilities when there's a union. We don't expect all of you to become labor relations professionals, but as Henry said, this is really a very important aspect of the job. And at some point in time, whatever job you're in, it's highly likely you'll have to deal with a union. So in the video today, we want to talk about conflict management in the context of where a union exists. So when there's a dispute in the workplace and there's no union, and two employees or employee and manager disagree, they talk about it. And if it's an environment that we talked about last week where it's open, transparent, there's a problem brought, the employees and the manager discuss it, and it's resolved.
And that's where, by the way, empathy comes in on the part of the manager.
But when you have a union, everything changes. A union gets there because employees have elected to be represented by a union. And as soon as that happens, there's a trigger. And the trigger is on issues of pay, benefits, work rules, and working conditions. Management does not have the right to decide by itself, and it doesn't have the right to take a couple of employees and decide those decisions. Management must deal with the representatives of the union chosen by the employees. So if you're in a theater environment and you have stagehands, you can't take two of the stagehands and say, I think we want to talk about a bonus program because we have a production coming in, we expect to make a lot of money, it's a very complicated set, so we want to give you a bonus. Can't do it. What you have to do is go to the union representatives that the employees have chosen. Usually they are employees of your organization, and you bring that subject up. When you have a union, once it's first established, the parties engage in what is called collective bargaining. The outcome of collective bargaining is a collective bargaining agreement. The collective bargaining agreement has a term, an expiration date. It could be 2 years, it could be 3 years, it could be 5 years. Historically, agreements ran 3-year terms, but more recently, terms have been longer. When you negotiate an agreement, you establish pay, benefits, working conditions, work rules. So in an orchestra, it will be how long is rehearsal? How many services can you have in a week?
How long is the break in a rehearsal?
So a collective bargaining agreement can be this thick because over the years, there have been disputes with management. They've been resolved in the context of the union management relationship and then memorialized in a phrase or a provision in the labor agreement. And so those labor agreements grow over time. And those labor agreements are definitions of the rights of management and the union. What we'd like to talk about is when there is a conflict in a unionized environment, how does it manifest itself? Well, let's say you terminate an employee for cause. The process is now that termination is subject to review by the union in some sort of a hearing. It's initiated by the filing of a grievance. It's a term of art. It basically says, I think management, you have treated me wrong, or I think management, you've broken a rule that is contained in our agreement. And the process that follows is defined in the collective bargaining agreement. And it is a process that looks a lot like a court trial where there is a hearing. Usually a member of management oversees as decision maker in the first instance. And the facts are brought out. And the manager says, yep, we did the right thing, or nope, you're right, we did the wrong thing. If there's a disagreement as a result of that, there are steps in the grievance procedure. And the ultimate step of that is to turn it over to a third party, who's called an arbitrator. The arbitrator is chosen by both parties. Both parties present their side of the argument, and the arbitrator will render a decision that's final and binding. And there's no place to go once that decision is made. Let's talk a minute about the collective bargaining process. When do you start preparing for negotiations? My feeling is, as soon as the ink dries on the agreement you just negotiated, you have to be thinking about the next round of bargaining. What's working, what's not working, what changes might you want to make? How do you incorporate that into a bargaining process that comes up? But let's talk about, as we did managing for success. You don't wait till the problem is there. The ideal labor management relationship is a collaborative one, where it's not management saying one thing and the union saying another, and it's a conflict. It should be a dialogue, a collaborative dialogue, where there's a continuous discussion of problems and a continuous resolution of those problems. And if that's the environment that both union and management has created, then the negotiation of a new agreement is usually a non-event. It's not an occasion for conflict. Henry?
Well, I was just going to say that during my time in managing as the sort of CEO of two orchestras, the National Symphony in Washington and the Chicago Symphony, every piece of financial information that my board of directors got, the orchestra's representative committee got also. And I was actually in 1981 in Washington, I was the first orchestra CEO to do that. My theory was very simple. Anything I don't tell them, they will make an assumption that is less in my favor than the truth. And if they actually know the real numbers, I'm better off. And also it goes to something Ralph talked about in previous videos about transparency. So I always shared everything, and I recommend that. I think that it's also important if something comes up, let's say you've finished a negotiation, you've signed a new 3-year contract, and a circumstance comes up that none of you foresaw. And the contract allows the management to do something, but that in your heart you know is not right. In fact, in the next negotiation, I'm going to have to give this up. You can win a lot of points by not doing it in the first place, or by saying to the orchestra's representative committee, we're going to do this because I'm allowed to, but I am agreeing now that I'll never do it again. We'll never do it again. It's just, again, that key word that Ralph brought up, empathy. Understand the position that somebody else takes and why. What's made them take that position.
I want to move to what happens when, in a collective bargaining, things break down. Now, as we said, the ideal situation and what every leader should strive to do is establish this transparent, collaborative approach so that when collective bargaining occurs, it flows through the relationships that have been established where conflict and disagreement is not handled as position bargaining, that is, I want to do this, you want to do that, and somehow we'll come up to a compromise, but rather it's issue resolution, with both parties identifying the issue and finding solutions. When it breaks down, there are several possible results. The ideal result is that when you are in collective bargaining, that the process ends and you're in agreement. What happens if the process ends and you're not? When a collective bargaining agreement expires, the union has a right to call a strike. What is a strike? Contract ends, let's say August 31st of 2020. The union says you haven't yet resolved all the outstanding issues, and we are going to exercise our right to strike. That means they withhold their services, and you continue to bargain until such time as you reach agreement. Strikes can be an hour long, strikes can be months long. The strike ends when an agreement is reached, or you might be able to negotiate an end of a strike pending the resolution of certain issues. So it can play out in many different ways. What happens if a contract expires and the union says, we want to continue talking? That's called play and talk, or continue to perform and talk. What happens in that situation is the contract continues without change until such time as a new agreement is reached. The danger of that situation is the union could call a strike at any time during that. So let's say a union says, let's play and talk. And you have a large fundraising gala 3 weeks after the date of the expiration of the contract. So they play and talk for 3 weeks. And 2 days before the gala, they say, if you don't agree to our terms, we're going to strike. That can happen. So play and talk is an alternative, but the union reserves the right to strike at any time. A third
Let me add one thing to that, by the way. Usually, normally, when agreement to play and talk is entered into, usually one condition of it is whatever changes we ultimately agree in on the new contract are retroactive to the beginning of this contract.
And that's usually a very contentious issue. So you should always be planning in the financial terms that whatever you agree to, and in negotiations, you have an idea of your end goal of where it will end. Make sure your budget is built with that retroactive payment built into your budget. Let's say, as another variation, contract expires and the management is asking for employees to take a pay cut. Well, they're not going to strike over that. They're going to continue to play and talk, because to strike is not to be paid. To play and talk is to continue to be paid at the higher level of the current rate of pay. If management is seeking a pay cut, you have no incentive to withhold your services. But management may be in financial distress, and to continue to pay under the terms of the expired agreement creates such financial stress for the organization that that reduction in expense becomes essential. In that case, management can lock out employees. What that means is management shuts down the entire operation. And the incentive to reach an agreement is, if you want to come back to work, then you're going to have to agree to the pay cuts that we have to have in order to maintain fiscal integrity. Strikes, lockouts are contentious. They should be avoided at all costs, but they're an essential part of the collective bargaining process.
And I'd say the hardest thing I had in my career, one strike, it was only about 2 weeks, a little more than 2 weeks long, very painful. And it's frankly in the performing arts world, particularly, I would say for a theater company, if you don't have your own company of actors, it's not quite as personal. But in an orchestra or an opera company, where as the manager, you have a day-to-day relationship with the workers who are now on strike, it's very hard personally it's very hard.
And it creates an atmosphere of confrontation, conflict, defending a point of view and a position, so that when the agreement is ultimately made, the scars of that contentiousness have now changed the culture of the organization, and the dialogue changes and relationships change. That's what Henry's talking about. And there's a price to be paid if there's a strike or a lockout.
But I would also caution the other side of that coin. I know some contracts that have been settled, and I may have done it myself, because you, as the manager, you wanted to avoid that pain. And you didn't want to have the group of musicians, which is, after all, why you're working, is to make it possible for them to make music. And I think it's a human tendency to maybe accept a settlement that really you can't quite afford because you don't want that pain. It's a very, very tricky area. In the theater world, it's different, especially if you don't have your own company of actors. You're dealing with unions, but in a different way, I would say. Even stagehands, it might not be your own stagehands. It might be all of the stagehands in a city that have elected a negotiating committee. So it's a little different.
If you take New York City, stagehands and Broadway, it's an extremely powerful union and can affect the entire Broadway production. So when unions have that kind of leverage, you want to ensure that you create this collaborative environment because you're vulnerable. Let's talk a little bit about what you're going to be doing this week, because this is going to be a fun week for you. We've given you detailed fact pattern about the Metropolitan Opera. This is 2 negotiations ago when the Metropolitan Opera was facing a huge financial challenge. And what we're going to ask you to do in your groups in the discussion board, each of you is going to be assigned a management role, or each group, one management, the other union. There'll be 2 spokespersons for each of these 2 groups. And when we come together in the Zoom, we're going to bring what we just talked about into a very practical application. We're going to have you, with Henry and I overseeing it, have a discussion about how you would defend your point of view and how you would convince the other side that you're right and they should agree to it.
It's sort of like we're going to sort of play the role of mediators. Mediators are often sometimes government employed, but also sometimes hired individually. Ralph and I have both done that, where both parties agree that this person can mediate, and you can't require a solution. You can only try to recommend one to both sides. So what we're going to be doing in this particular assignment is you are going to make your case, management and labor, make your case to the mediators.
And to define a mediator, you remember we talked about an arbitrator in a dispute resolution, where the arbitrator is chosen by both parties and the arbitrator decides and it's binding. A mediator is a person who comes in and listens to both sides and tries to be the person who goes back and forth in shuttle diplomacy to find the areas that the mediator thinks they can find is common to both, and find those, and as he finds each thread, or she finds each thread of potential agreement, weaves together that ultimate nexus of issues that result in an agreement. A mediator, when they see that perhaps that's not going to work, can also come up with what is called a mediator's proposal, where the mediator has a sense of what each side might agree to, and so puts it down in a mediator's proposal. Here are all the issues, and here's how you might consider agreeing to this, because it's not going very well. Having had the conversations individually with both sides, and then sitting in a room when both sides then came together, the mediator hears things from both sides privately and in the collective discussions that informs the mediator of where the agreement might lie. And usually mediators are very good at picking up these common threads and then weaving together an agreement with the parties. It's a fascinating process.
Good. I hope you'll have fun with that exercise, and we thank you for watching.
Thank you, Henry.